Welcome to Real World Real Estate, where we will explore, examine, and explain the real process of buying or selling real estate. Here is your host, Stephen Clyde.
Hello, everybody. Stephen Clyde here, your host of Real World Real Estate with RE/MAX Preferred and RE/MAX at Cherry Hill. And today we're going to be interviewing Joseph J. Console, who's a founding partner of Console Matison law firm with a concentration in real estate law. And we're going to be discussing how the law applies to buying or selling your house. What does this 9-page contract entail? What does it mean to you? And why you should have an attorney representing you as you go through. Joe is a local South Jersey boy, born and raised in Voorhees. He went to St. Joe's Prep in Philadelphia. That's basically because he couldn't get into St. Augustine's Prep like me, but
right.
Undergrad from Temple and his JD from Rutgers Law. He started in land use and municipal law at Platt and Riso, and then founded his own firm. And we've been using him for our clients for a while now, and we're very comfortable with him, and he does a great job. So, Joe, thanks for joining us. Appreciate you being here.
Stephen, thanks for having me.
No problem. You want to expand on that little introduction I gave you a little bit and explain to everybody who you are and what you do?
As Stephen said, Joe Console, my current firm's called Console Matison, LLP. We specialize in all aspects of real estate law, as well as probate and estate law. And my partner, Scott, is an excellent divorce attorney. We practice in Pennsylvania and in New Jersey. I've been practicing for 13 years now. Stephen mentioned I am from South Jersey. I cut my teeth at a small firm in South Jersey that does a lot of municipal representation. I enjoyed the land use piece of it. And when I went out on my own, I just started telling people that I was a real estate attorney. And that was in 2012. And slowly I have amassed clients on both sides of the Delaware River in New Jersey and in PA. And I represent a lot of investors, a lot of real estate agents, and just a lot of buyers and sellers generally.
So just so everybody knows, because the podcast will go out everywhere, we're going to be talking about New Jersey and Pennsylvania laws that applies to the contract language, right? Because you're a member of both of those bars.
I am.
That's the contract we have in front of us. But when we're talking in general terms, that'll apply to most of the country, I would think, right?
Well, yeah. I can't, as a lawyer, I can't really speak for how different states, like, for example, I'm sure we'll get into the attorney review period in New Jersey, that squarely does not apply in Pennsylvania. So I can't say what a Delaware contract looks like,
Right, but when we're talking about legal terms, when we get into time is of the essence.
Oh, sure.
Yep. The general stuff is going to apply across the board as general legal doctrine for the most part. Specific contract language, anybody in their state is going to have to contact a local attorney in their state and a member of their bar, pretty much.
Correct. And nothing I say today is considered legal advice.
And as we discuss this, I'm not a lawyer. I'm not practicing law without a license. I'm not a member of the bar. I did sleep in a Holiday Inn Express last night, though, so that should qualify me, right?
Man, they let you stay. That's nice.
They let me stay, right? So let's start in, we have basically two different ways of doing business in the region we're in, right? We have the South Jersey / Philadelphia format. And the South Jersey one varies slightly from the Philadelphia, Pennsylvania one. And then we have the North Jersey version, Mercer County up. So the biggest difference between the two of those, Joe, if I understand it properly, is the Philadelphia, Pennsylvania market and the South Jersey market, buyers are not required to have an attorney. But when we go into North Jersey, it's a requirement for the most part.
It feels like a requirement. Certainly, whenever I get on board for a North Jersey deal, it's not a question of if. It's just, all right, here's the seller's attorney. Please, represent the buyer and get started on the attorney review period. Whereas in South Jersey, it's more of a negotiation with the buyer or sellers themselves to see if they want an attorney, and more of a trying to sell my service versus in North Jersey, where they know that they need one because I guess custom has handed that down, and that's where it's at.
Right. So then let's jump into, I've got the contract up in front of us, and this is a New Jersey contract. So I want to preface that. So this is our normal cover page, which I understand this is what I refer to as Opinion 26 from the Attorney General's office, which is basically stating to them, I'm a real estate agent. I can't give you legal advice. I can't give you guidance. And, you should get an attorney to do these things, but it's your choice. This is like you have the right to remain silent moment with a Miranda right in a real estate transaction, right? Like,
yes, correct. And I'm sure we'll get into it in a second, but the language around the attorney review period basically states that buyers or sellers that are involved in a contract prepared by a New Jersey brokerage are required to have an attorney review it. If they choose not to, then they don't have the option of backing out of the contract within the first 3 days. But if you do have an attorney, either side can back out pretty much without any question. You can just choose to cancel the contract.
Right, no explanation whatsoever. Because that 2-sentence letter, I declare this contract null and void. Please return all deposit monies, right? That's the simple statement, right?
That's it.
When normally when I get that attorney review letter on this side, it's not so bad when I'm dealing with South Jersey or Philadelphia attorneys that are members of both bars, but it gets complicated when I have North Jersey attorneys, that I'll see anywhere from 5 to 20 changes to the standardized contract.
Yeah, when I first started doing this, I was almost shocked at the difference in how attorneys in North versus South Jersey handled their responses. And it's exactly what you said, to the point where you just say, are they doing this? Are these attorneys adding so much and subtracting so much just to try to prove their dollar worth to their clients? Or is it just a form letter that every contract gets? I think it's probably a little combination of both.
I think it is a combination of both. I agree with that. And because I've seen some of them where the form letter comes through from the paralegal, and then I have to call them up and say, that one doesn't apply to, your number 6 doesn't apply to this contract. Do you want to revise it? Or? So as the buyer is progressing through, so let's look at it from twofold. A client or seller, a buyer or seller who opts for an attorney versus the one that doesn't. So, they get the contract from their real estate agent. They e-sign it, which is, what 90% of people doing these days. Mm-hmm. If they opt not to move forward with an attorney or to retain you or one of your peers or something like that, what are they opening themselves up to? What's their additional risk versus the one that hired an attorney?
Well, first of all, do you as a superstar agent, do you let people know about that option? I mean,
Oh, absolutely. That's the first conversation. Like, look, you have a right to an attorney. At no point do you ever waive that right. You engage them now, or you can engage them at some point during the transaction, but it's entirely your decision. And here's a list of qualified real estate attorneys. Yeah, I think as a real estate agent, the only thing I really cringe on. And I don't know how to say this without jamming anybody up, but I guess it's like, the medical field, right? They all went to the same school, but then they specialized, right? So a GP, lawyer who's doing wills and slip and fall cases and, whatever else he's doing during the normal day, and then decides that of the 30 things he's handling, he's going to do a real estate contract versus the attorneys that are real estate attorneys. I kind of cringe at the GPs that are doing this as one of 30 different things they're doing that day versus someone like yourself, that this is what you do and this contract back and forth. And I've sat at the table with both of those. I think the funniest one I had is I had a well-known attorney who was actually a mayor in a large South Jersey town representing a client, and he was making a dispute at the table. And while he was flipping through that contract looking for what he was disputing, the other attorney, who was a dedicated real estate attorney, wouldn't even do litigation, just came out and said, you're looking for paragraph X, but it doesn't apply because of this, because they knew that contract and that case law off the top of their head. So yeah, we advise them all. We don't push any clients either way. It's entirely the client's decision. Obviously, it makes my life easier if they retain an attorney, because I don't have to handle home inspection negotiations or reviewing title or surveys or any of that stuff. So
Well, yeah, that's what I was going to get into. So in North Jersey, it's just de rigueur to expect that the attorneys for both sides will handle any point of negotiation along the way. Like you said, the inspection replies, any addendums, having to push things back. And as attorneys do, we just try to be, good mediators between people's emotions around the home purchase or the home sale and the other side, because, oftentimes people fly off the handle, and attorneys serve a good purpose there. In other situations, I find myself doing a lot of explaining contract language to buyers and sellers. And even for just thinking recently, I've had elderly folks that actually want me to be present at the closing table, because obviously not since COVID, but to speak about, to walk them through all of the documents they'll be signing, because they just want to feel comfortable that they know exactly what they're signing each time they sign it. And that adds, some time and effort on my part. But those are the kind of things that I think that we bring to the table in real estate transactions. And I think it's peace of mind for people too.
Yeah, it's absolutely peace of mind. And it's a very complicated transaction, right? And, we all pray and hope that when we sign that initial contract, it's going to go smooth as silk all the way through. But as we all know, that's not the normal case. I mean, look, we're involved in one now, each of us for a client, where a dispute over who's getting a certificate of occupancy, right? I mean, it's clear to everyone on this side of the table reading it that it's the seller's responsibility, but obviously the seller's not reading it that way. So I see that's where you guys come in and clarify language for the most part.
Well, right. The idea of, there being a dispute over something that seems clear to one side sort of doesn't take into account that there's a lot of emotions involved. And if in this scenario, you and I are totally correct about the seller's responsibility for the certificate of occupancy, if they're going to die on that hill, that may mean that you don't get the sale, your client doesn't get the property, and everyone leaves pissed off. So there's a little bit of an art, I think, on my end in terms of how to handle different personalities and people's, varying levels of anger at a situation that might not always, negotiations might be smarter than digging our heels in, at first, always. And then we see where it goes from there. Worked out, luckily. It seems like it.
Yeah, well, it's working out. Let's not change that. But I agree with that, right? We all, I think, from the attorney's point of view, I mean, from the attorney's role and the real estate agent's role, or basically all the professionals involved, a lot of times our biggest task is to protect our clients from themselves, right? And like, as you said, remove that emotion from it. We're dealing with it from a business standpoint. It's a home to them. It's their personal home. It's where their kids grew up. It's where, their daughter left for marriage, or the son broke their arm, whatever it may be, all those memories and everything attached and that emotion attached to that house, they can't separate that out. It's our job to do that and give the counsel and keep them calm and relaxed during this. Yep. And we don't want like you said, once you dig your heels in and draw that line, it's hard to back off from it. So, all right. So the client signs the contract, they initial all the way through, we refer them to you, then you're going to take the contract and review it. And one of the things I see that I would think 90+% of attorneys strike, especially in a South Jersey contract, is time is of the essence.
Yeah, so, isn't that weird that always happens?
It's consistent. I mean, it's so. Let's talk.
I went back and recently have started revising my buyer's letter to add a couple things, and I noticed from the very beginning the ones that I had cribbed from the first law firm I ever worked at had that striking of time is of the essence. The paragraph number was different. 11 years ago, it was still in there.
So yeah. What is the importance of time is of the essence? How does that differentiate from striking it? What is time is of the essence if we put it in layman's terms and not legalese?
So layman's terms, I would say the best way to think about it is, say, for example, what's a good example of something that might be a little fluid?
The lender's mortgage commitment. Or
So
the home inspection time frame for scheduling purposes.
Yeah, we'll say the lender's mortgage commitment is due 10 days. And the lender responds on the 10th day and says, I'll have it for you first thing in the morning tomorrow, and here's the reason why. The time is of the essence clause means that if anything is technically late by even a minute, then that triggers a breach or a potential breach in the contract. Meaning, if the buyer fails to provide their commitment, and it comes in at 12:01, that technically is a violation. Even though what we call in the law de minimis, meaning you barely missed the deadline, and therefore you shouldn't be prejudiced because of it. You did everything you could to make it happen, and for reasons beyond your control, it sort of just ran a little late. We strike the time is of the essence clause, and we really just rely on people's best efforts to get things done. And it doesn't automatically create a breach. It creates a situation where the lender says, I'm not going to have it to you by midnight tonight. Then the other agents and attorneys can speak and say, it's going to be tomorrow. Is that going to, is that going to really be a huge deal here?
So if we don't have it, and let's say the 10th, the 10-day comes and the lender says we need another 10 days. Is that, once we remove time is of the essence, is that opening us up that we there is no enforceability of the timeline? Or is there a guideline in the law that says, even though time is of the essence isn't there, you need to cure that situation within this time frame?
Times of the essence, as I understand contract law, is really important for delivery dates. So closing would not be something that you could just haphazardly push off. Delivery of property and goods, I believe, is how the law thinks about that. But minor things along the way, I think won't suffer from removal of the times of the essence. But things like the closing date, even if you remove that, you still can't just randomly change the closing date, because that date is held to be sacrosanct.
So then, I'm glad you touched on something, because, I went through a situation recently where the other side was demanding, 5 p.m. deadlines. And it's always been my understanding that the law looks at it as a day. Like you said, as long as you have it done before midnight of that day, that's count. You can't set a timeline in it unless there's something specific in the contract to that time, to a time in the day, right? Like, so.
Correct. Yeah. The law in New Jersey is clear that 11:59 p.m. is still the day. You'd have to agree otherwise that, all communications must be received by, 4:59 on any given day. And it's not something that can be unilaterally created. And, your business is just one where real estate itself, a lot of people have jobs and they're not in a position to sit down, review things and DocuSign them between 9 and 5. And you get a lot of stuff that's stamped between 5 and midnight. And there's nothing wrong with that.
So the day is the day. So if we say it's the 31st, you have until 11:59 on the 31st to finish that, or to deliver your task, or to complete your task or such.
Correct.
Okay. So then as we go in, and let's say we touched on the mortgage commitment from the bank. So as an attorney representing either side, when that commitment comes in, what are you doing with it? Obviously you're reviewing it, but what are the next steps? Meaning
just reviewing it and make sure it's satisfactory, and then flipping it to the other attorney. That's correct. That's sort of what I do. And, we keep the case on track in that sense, and that, I have an internal timeline that I'll share with clients where things are due. And, as they get sent to attorneys, we have everything time stamped, just so it creates a record of the transaction, which, attorneys are respected in the sense that if I had shown emails that I sent something, in time, the courts aren't going to question whether or not I was, forging an email or something like that.
Right. You're given the benefit of the doubt as an officer of the court that you did what you said you did, right? You take you at your word.
Correct. Yeah, that's a good way to put it. Benefit of the doubt.
They give you the benefit of the doubt, right? So then some of the other changes that I've seen is they always strike out the commission part of it, right? If either party doesn't close, we have the right to our commissions because they were earned when we signed the contract. That's always a strikeout. But what are some of the normal things that you strike from the contract or you change in the contract for a buyer? What should everybody be on the lookout for the most part?
My most recent one from this morning. Let's see. Time is of the essence gets nixed. We always nix what we call automatic waiver language. That's paragraph 16.
So what is automatic waiver language?
So basically, in respect, when we're talking about the inspection contingency clause, the automatic waiver states that if a buyer fails to, so if you present your list of repairs to the seller,
right,
and he says, I'm not doing this, I will do this, I'm not doing this and this, and you fail to respond, by the minute that he expects you to respond, the automatic waiver says that you've therefore agreed with everything that the seller has said. Removing the automatic waiver basically says that the seller effectively countered your offer, and a response on your end is required. And so instead of you just defaulting and being held to determine that anything you didn't complain about is now your problem, this says that the seller has got to basically say, you failed to respond. I need a response by blah, blah, blah. If I don't get it, I'm going to consider this to all be, to you having okayed all this. So it's not automatic. The seller's got to give you an opportunity as the buyer to respond to what they said.
So that's the old adage, he who was silent has said the consent?
Right, exactly.
You're basically reading that away?
So we pull that out of the inspection piece.
Okay.
A couple other silly ones in this clause, paragraph D, we add that if the inspector's report is late and we can prove that we got it, we can extend the inspection time period. So that's something that I add. The inspection time period may be extended pending the receipt of the written inspection report from a qualified inspector. It gives the buyer a little bit of peace of mind that if their inspector is a day or two late, that the sides have the ability to negotiate that and say, we're going to work on it the second we get it. Although good inspectors don't ever appear to be late to me. You may have different opinions on that. But
so basically, what you're saying there is if, in our contract, it defaults to 14 days if left blank, but some agents change it to 10 days.
Yeah.
These are calendar days. I'm talking about everybody, not business days. So as long as we completed the inspections inside that timeline, but we just haven't received the report back from the inspectors yet.
Correct.
We're not waiving that period, right? We didn't give
Correct.
it up.
That's a more succinct way of saying that. Yep. Yeah. You don't lose it if you can prove that he went out there and inspected, and usually everyone knows when that happened because people have boots on the ground and they know an inspector came and that a report's pending. And then I would assume, this seems like a pretty narrow circumstance, but that the inspector would reach out and say, I'll have the report done, tomorrow or whatever, but I did complete it on this date.
So before you go on to your next change, while we're on inspections, I want to touch base on this because this is one spot where Pennsylvania does differ from us drastically. But while we're still talking about New Jersey, I'm buying the house, we do the inspection, and there's $50,000 worth of structural and material defect repairs that need to be done. Significant. But the seller agrees to have those repairs all completed. I, as the buyer, in my understanding, as long as they say yes to everything that needs to be done, I have to move forward no matter how extensive those repairs are. Is that a correct understanding of it? Or in New Jersey? I know it's different in Pennsylvania.
That the buyer has to move forward?
Yes.
Yeah. Your response presenting the list of repairs is a counteroffer, essentially, against the purchase price or a demand for repairs. And if they agree to it, that relocks you into the contract.
I can't say I'm not happy with the repair. Well, and again, specifying New Jersey now, I'm not happy with the repair, so I'm not moving forward with the buyer. That option isn't presented to me in New Jersey, correct?
Correct. And I've been down a couple rabbit holes in PA where to everyone but one buyer out of the husband and wife, everyone's happy with the repairs, but a deal gets like torpedoed because someone's not happy with how the wall was closed or the trim was replaced. And it turns into this whole thing where suddenly the shift of power is so strong. New Jersey doesn't put you in that position necessarily.
So let's jump over to that. I don't know if it's a statewide contract in Pennsylvania or if it's our southeast region, Philadelphia, the surrounding suburbs. That buyer's granted 3 options, if I understand right, or how does their home inspection clause work? Right, get an accept, a cancel or the negotiation that looks like New Jersey, right, where we work out the repairs.
Right. You get another 2 days to negotiate if you're not going to accept the seller's offer in Pennsylvania. You come back and you say yes, but no, but that sort of thing.
Okay.
And that's interesting. I hadn't thought much about how the quality of the repairs factored in, to all this in PA and New Jersey. So that's actually an interesting thing you brought up for me.
Well, on this side, if I write the letter on behalf of a client, or I help the client write the repair letter, or their attorney does, it's always specified that it's licensed, qualified, insured contractors with documentation and everything provided, that we don't want a homeowner correcting an electrical issue or a plumbing issue, right? Because we have no recourse back on the homeowner. There's no, tradesman's guarantee on it, so to speak, I guess.
Mm-hmm. Mm-hmm. Do you find that in either PA or New Jersey, there's more? It's apt to be more at the closing table negotiations for minor things related to repairs. Yeah,
I find in South Jersey, I'm not going to speak to the north, but I think they're pretty much the same as we are now on this, that we have these issues resolved at least 5 business days before closing. We're not doing it at the table.
Mm-hmm.
And we're requiring that documentation in advance.
Mm-hmm.
Just because of the TRID requirements, the 3-day disclosures and everything,
mm-hmm.
we're trying to get all that resolved way in advance, because if we're dealing with it at the table, we're running into mortgage issues now. Right, because the last thing they ever want to see on a sheet is something that says repairs.
Right.
But I got to say, so as we're going through this, as you mentioned, it may be a credit for these repairs, and maybe the repairs done. I always look at it if they're black and white repairs, right? It's replace an outlet or a light, or something that's very definitive. Credits are fine, but when we start getting into structural issues or termite issues, or things where a wall has to be opened up, where, hey, yeah, this is $2,000 unless we find additional hidden damage.
Yeah,
they're the ones that I always advise my client, you don't want this credit. You don't want to take on that right? Because once we take the credit and we get up and walk away from the table, if that $2,000 repair becomes $8,000, that's on you. You can't go back to the seller now, correct?
Well, right. That looks bad for everyone on the buyer's side in the sense that the seller is picking a number that they believe is an adequate loss on their end to, what's the right word, to insulate themselves against having to worry about what's behind the wall. Like you said, those things quickly add up. There's not many, $2,000 jobs that stay at $2,000, because there's always, we open the wall up and there's some knob and tube in there, or
there's termite tubes, or
right.
Oh, your stucco has been leaking for the last 20 years, and your wood
There's
is all
definitely some rot behind that stucco. How much that cost? How much does that cost? $25,000. Okay.
Correct. Yeah, I've seen those, and that's why we, unless it's, hey, you're changing out an outlet, or you're replacing a faucet, or patching a pipe. Those simple jobs that we can say, yes, that is fixed. There's no additional hidden damage. Take the credit for that, not for the other ones. So are you seeing anywhere, and I don't see it very often because nobody wants to do it, where there's escrows going in for these repairs? Because I know over here the title companies don't want to touch it unless
it happens a lot. It happens a lot in Philly proper, but more so not for repairs. You're right. In Philly, there's a lot of issues around what's the actual outstanding water bill that's owed to the city. It might be that the city takes 3 or 4 weeks to give you a straight answer, and so at the point of sale, the what everyone comes up with is, let's hold 1.5 times what we think this bill actually is, and then so that sort of thing in terms of escrow agreements. But for the sales, I don't see it really often, if at all, in Jersey that I can think of.
What is after you pass inspection, what's your next big change?
All right, so we'll get past the inspections. So I guess just adding, let's go to paragraph 24.
Okay.
Because I think you had started to talk about this before regarding risk of loss, and damage. So there's an idea that's actually in all of the PA contracts, that the buyer doesn't have to go through with the sale if between when they put their offer in and when they close, there's a significant amount of damage to the property. And so what we like to add is in New Jersey, if the damage to the property exceeds a certain percentage of the purchase price, just call it 10%, that gives the buyer the option to cancel the contract and not, expect to take the property with significant damage. Even if the seller is going to fix it, they may not want to move into a house that just had a car driven into the kitchen or something like that.
If we go through a nor'easter or one of our big storms and a tree falls through the roof, that's the kind of stuff you're talking about. Or if, God forbid, a fire breaks out, or
yes,
pipe
correct,
or something like that. Insurance claim type of triggers we're talking about here, or
yeah, I would think so. And have you run into a situation where the property damage was severe in that time period?
Not yet. No, thank God. Knock on wood on that one. I'm sure it's going to come to me at some point, but I haven't yet.
Yeah. So if you don't address it, basically the buyer has to allow the seller to agree to fix things, but we try to cap that and say, there's substantial loss. It might not be the same property that the buyer wanted. He may be, have been attached to the kitchen cabinets. Who knows? But it allows you to walk and allows the buyer to get their deposit back.
Okay, cool. That's a good idea. I like that one. All right. And then 25 is our initial walkthrough, which is pretty common. And then 26, I never see anybody do anything with 26 on the adjustments and the prorations on closing. That pretty much always stays the same for everybody, right?
Yeah. My next big one is just the blank space, paragraph 43. I try to add, unless there's something I'm missing.
Well, 27 brings us into if the seller fails to close title on the property in accordance with the agreement of sale.
Mm-hmm. Yeah, I just to that I just add at the end of the paragraph damages that it has suffered. So the last paragraph read: if buyer and seller breaches contract, the breaching party will nevertheless be liable to brokers for the commission amounts as well as reasonable attorney's fees, costs, and such other damages that it has suffered as are determined by the court. That's language that I see thrown into every buyer's contract. I don't really know how it changes that paragraph, to be honest with you, but I've adopted it.
So let's touch base on that commission one, right? Because in the law that we're held under the real estate commission and everything, we earned the commission the second we put a willing buyer and a willing seller together. Mm-hmm. Job is done. Tradition is we wait till settlement to be paid, obviously, because that's when the money's going to change hands. So, and in almost 20 years and 1,000 transactions, I may have threatened this paragraph a few times, but I've never actually had to execute this paragraph. Mm-hmm. It's my understanding that if it does fall through, I can only sell. The broker can only sue for his commission if he doesn't resell the house, right? He doesn't get two bites at that apple, right?
Correct. And I think it's wise language. I think there's probably a lot of history of sellers torpedoing a deal and then just trying to get another broker to sell the property, even though broker one did everything that they were supposed to appropriately, got them near the finish line, and for whatever reason it fell through, possibly because someone got in the seller's ear and said, "You can do better. I can't believe that you signed this contract." He says, "Well, my agent said it was," whatever they might say. But that's how I could see that playing out.
So let's stay on 27 again. So let's say either party, settlement is the 31st at 4:00. Everybody got their scheduling notices. Everything's good. The mortgage commitment's done. We have it clear to close. All the I's were dotted and the T's were crossed. But one of the parties opts not to show up and not to move forward.
Yeah.
When we start looking at those damages, what could those damages be? And does the party that didn't show up, do they have time to correct the situation or cure it, so to speak?
Well, in terms of what the damages could be, I get into things like equitable relief for the buyer. So seller bails, the deposit's out there, closing was supposed to happen yesterday. What can I do as the buyer? The law allows you to initiate a lawsuit to force the sale, which is accompanied by what's called a lis pendens. A lis pendens is a notice that the property is under a lawsuit, and it effectively prevents that seller from selling the property to anyone else. until the lawsuit's worked out or until they come up with a deal with the buyer to either drop it, for cash or to actually sell it to them.
So if we're on the other side of the table and let's say I'm the seller, you're representing me, the buyer never shows up. I guess off the top of my head, I would say I'm looking at whatever I spent to get to that point, right? Whatever my were.
Yeah. So the seller's damages are consequential. Obviously at that point, the deposit's forfeited, but then it's a question of what was reasonable consequential damages that the seller would have invested in to get where we're at. And then past that, you talk about things like lost opportunity cost, where the seller, just did this dance with the buyer for 3 months, and now that the buyer has walked, what's that worth to the seller? And that is a trickier and frankly less easy piece to prove. Whereas, the deposit's the easiest, and then the consequential out-of-pocket monies, attorney's fees from the seller that he has to come out of pocket to try to get the sale to happen, commissions that are due because his agent did a good job, and I'm sure there's a few other things in there.
Not in today's market, right? Today's market, the deal falls through tomorrow. The seller can resell it for $5,000 more. But in a normal marketplace during normal times, the deal falls through. Now the property's a little tainted because it's been on the market now for 120 days while I was waiting to go to closing. Pops back up from being under contract, so it's got, what happened, what's wrong with it, stigma on it. So now they sell it for $10,000 less than that contract that was broken. Does that become part of their damages as well, or?
Certainly. And what I was going to say to you about that point is, and I guess I never talked to a Jersey agent about this, but the idea of putting it back on the market, when can you call it a new listing? You know what I mean? Because I've seen that get days reset to 0. Right. Is there a certain time when that's appropriate and when it's not in this scenario?
We can reset it as a new listing and we can get a partial 0, because this is New Jersey, actually from Mercer County down through Virginia out to Lancaster, because we're all in the same MLS now. Mm-hmm. They have the relisting days on market, which would restart at 0, but then it has the total days on market next to it.
Gotcha.
If we come back on and you know what, you say this deal fell apart and it was my agent's fault, my broker's fault, I'm not going with them, I'm canceling my listing contract, and I'm going to relist with broker, XYZ. Well, broker XYZ comes back on the market at 0 days, but right next to that number shows the days with the previous broker, mm-hmm. or how many previous. It's your total days on market. And I think what I've seen, you have to be off the market for over 30 days to reset both timelines.
Gotcha.
And I got to double check because the MLS is changing that all the time. And, we're getting new adjustments. Like, they changed the rules. We can't do exclusive listings anymore. Mm-hmm. Mm-hmm. We can, but we're not allowed to market it in any way whatsoever. So there's all new MLS rules that we can get into in depth that go way outside of this contract and kind of like what I call the inside baseball part of it. But let's stay on that relisting it, because this is something I experienced recently while we're touching on it.
Okay.
You're in the midst of resolving issues, or you hope you're negotiating to resolve the issues. And the other side says, no, we're just putting it back on the market again, but you still have a contract that's in force for another 10 days, mm-hmm. right? They don't have that authority across the board to arbitrarily declare the contract null and void just because you're hitting a deadlock in negotiations, right? And to go back on the market again.
They don't. Certainly not. And I think that is less the purview of the law in New Jersey, so much as it is the ethical boundaries that realtors, the strict ethical boundaries that realtors are held to as being an agent. So it's more administrative no-nos that can cost you your license if they're severe enough, right. Not something that I could sue an agent for, but something that would be an easy one to bring up to the board in Jersey and have that attorney that agent scrutinized for acting inappropriately, because the MLS and the real estate commission, they're intertwined. So things that you put on the MLS as a real estate agent, that's your ethics on the line.
Understood. Yeah. Okay. So, we're held to not quite the standard that you as a member of the bar are held to, but we do have a fiduciary standard and ethical standard that we have to live up to. And one of those is putting our client's interest at all times in front of our own. And then as we talk about that settlement, so, when the notice of settlement's filed, and I don't know if this applies in Pennsylvania or not, when that notice of settlement's sent to the county clerk's office, that kind of protects the buyer a little bit, right?
It does. So that I don't know what happens to that for the days past the settlement date, but it certainly it will come up if you were just trying to sell it out from under the buyer that got so far as to actually filing that notice of settlement.
Right. So let's say they breached and we have an unethical party on the other side and they try to resell it because, hey, the market moved in my favor and I can get an extra $50,000 from XYZ and I don't have to pay the commission, so I'm not going to settlement. When that new buyer runs their title, they're going to come up with your list pendants and the title company's notice of settlement. So that buyer is immediately going to be notified there's an issue here, right?
Well, correct. There's a discharge form that has to be filed by whoever filed the notice of settlement, which discharges that notice of settlement. So that is what allows a new buyer's team to say, all right, we saw there was a notice of settlement for October 1st, but that was discharged on October 15th. So there's nothing in here that would prevent us from closing. There's no active litigation, that sort of thing.
So my understanding, until that notice is lifted, well, and I assume it's the whole state, but again, I guess no South Jersey better than anything else, that it's 60 days on either side of the settlement date?
Yeah, the way the law reads is either a notice of discharge or a 60 days from the date listed on the filed notice of settlement.
Okay.
Yeah, and so those the two things. So on day 61, you can, and it sort of allows a little bit of a cooling off period where as long as the seller, if you weren't being duplicitous, you could start marketing the house the day after the buyer failed to show up or whatever, and then 60 days from that then would be about a reasonable time to resolve everything and get it to closing, even if the buyer's not helpful in removing it.
So I've had issues in the past where I had to call the bluff, so to speak, and it turned out not to be a bluff, where the other side says we're not going to close, and I do show up with my clients, and we get the notarized attendance document signed and filled out by the title company that we were here, ready, willing, and able to close. Once that occurs, and again, you pick up things over time as experience, that I've been told by other attorneys that that client, that person that didn't show up, even though we documented we were there, that the courts are giving them like 10 days to cure whatever they did. Is that accurate or is that inaccurate?
Well, the 10-day cure period would you even get in front of a court within those 10 days? I'm just trying to think when that.
So does that 10 days start from, that's what I guess, is it once we file something against them, which could take you a month to get even your paperwork into a court, or is that from that 11:59 on settlement day? Do they have 10 days from then to cure?
Well, right. So I guess what you're saying is, it's the minute after you file a complaint, but 10 minutes after the buyer comes back and says, I can close now. There was a glitch. That the court would likely say you came through within a reasonable cure period. We'll call it 10 days, and therefore the buyer didn't substantially breach. Everything else remained the same, and so therefore you have to go through with it.
Okay,
is that what you're saying? Yeah,
that's what I was saying. Yeah, how's that play out again? All right,
and that's how it would play out. They would say, "Why are you pushing this through to court? You wanted to close. They barely missed it. They kept you alert and aware of what was going on. I'm going to dismiss this. You guys should just consummate this deal."
So then some of the other tests, because that covers most of the contract, the major important things, except for disclosures of who the agents are and the licensed professionals. And if there's an agent involved in the transaction, a licensed professional that's a buyer or seller. And, obviously when we're involved in the transactions, we're held to a higher standard than Joe Schmo Public when they're involved in the transaction because we're all licensed. So the other part you're handling, especially on the seller side, so you're taking care of their deed, any possible judgment issues, their affidavits, all of that documentation. As a seller's attorney, you're drafting and taking care of that. And then as a buyer's attorney, you're reviewing what that seller's attorney has done, right?
Right. There's the resident or non-resident affidavit. We do that. There's the deed. I mean, that language is so standard now that it's for most transactions, it's just what it is. Kind of just putting the deed together and then having it be reviewed by the other attorney.
And then you're going through the judgments with either the buyer or the seller, whoever you're representing. You're reviewing those judgment issues and the AKAs and all of that stuff.
Right, and that stuff oftentimes leads to other good work for me. But yeah, if people have a common name, you'll find that stuff pops up. So we're providing the title company with more narrow details to allow them to take certain things off the title report. Reaching out to who we have to. There might be old mortgages that need to be satisfied that no one's responding. So the lawyer's got to jump in and try to shake a couple trees and make something happen. That's the kind of things we do with the title report.
And then you're really not doing much with the mortgage documents on behalf of the buyer. You're just confirming that the terms and everything that they agreed to with the mortgage company are accurate, right? Because we really can't alter those documents at all.
Well, right. It's just the scenario, like I said at the beginning, if the buyers want me there at closing to tell them, what a personal guarantee is, and just to walk them through and explain things, that's my only real involvement with that. I just assume people know what a mortgage is, but that might be just me,
We joke with them a lot, saying, that entire 2 inches full of paperwork only says two things: you pay, you stay; you don't, you won't.
Right. Yeah, but things like how late is late. Like, I feel like that's something that people don't necessarily get. It's not like your rent, where on day 6 you can get a lawsuit filed against you. That's not how it works with your mortgage. So there's a couple other pieces I think are good.
And then I know there's a clause in our contract that says the seller is not liable to the buyer post settlement, but I would assume there are exceptions to that. That's not a blanket immunity, right, so to speak?
Yeah. So what you're referring to would be like a seller's disclosure issues, where after the settlement occurs, it's learned that the seller was inaccurate or failed to include information about their property that if the buyer had known it, the buyer might not have bought the property or would have requested other additional repairs or changes and that sort of thing. And those lawsuits are difficult from an attorney perspective to prove. You need to prove. It's easy where the seller lies and says, I had the roof replaced in 2015 when really it was 1995. Those are easy. The more difficult one.
Yeah, I had one in Cherry Hill once where, it had a beautiful brand new master bath, which was great. And that disclosure was marked off. There was never any flooding, plumbing issues. Everything was marked no, 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 no. And then we came to find out that he had a $35,000 insurance claim for a broken pipe. And that's what created the new master bath. Mm-hmm. They fully failed to disclose that to us, right? Because we would have wanted more explanation on it. Was all the mold taken care of? Was damaged wood replaced? We would have looked for things that we wouldn't have looked for other than just, hey, you got a new master bath. That's great. And then I've seen agents where, you point that out to them saying, hey, you marked no here, but, we have evidence that should be a yes. And then I've seen agents that go back and try to redo and amend that disclosure. Is that legitimate, or is that almost admitting guilt at that point?
Well, it's from an agent's perspective, and you might know more than me, although I've studied this a bit, is the agent has to tell you what he knows.
Correct.
But if they don't know it, you can't.
Right. But like the seller, I'm saying the seller did it, and then they send me an amended disclosure making that change.
Right. And have you ever been in a position where the seller comes back and says, actually, I might have flubbed a little bit when I wrote no here, and then you've got to come out hat in hand and say, here's the amended disclosure?
Oh, yeah. Well, I've had a client that, unbeknownst to me, outright lied by omission. I had one where We went to settlement in November. In February, I'm getting a call from the other agent saying, hey, the front lawn's flooded because the water main it broke and they're flooding out. And I'm like, well, we went to settlement 3 months ago. Why are you calling me?
That's too bad.
We have a copy of a letter, that was certified from the water company that was sent to your client back in July that they needed to address this.
Mm-hmm.
And my clients never put that in their disclosure. So, that was, luckily I had a client that I don't remember what their reasoning was, but they backpedaled a lot and they paid for the repair.
Mm-hmm.
But I think they paid for the repair because they were concerned over fraud charges.
Right. And I've seen that go all kinds of ways. A situation where the seller lives in Florida, according to him, 6 months out of the year. And the notice that there was a water main break came to him, was mailed to his New Jersey address that he was trying to sell while he was in Florida for 6 months. So he never got it. Everything was done remotely.
Right.
And you're suddenly like trying to prove to the court that because you didn't because you might not have checked your mail, you aren't responsible for, having told the buyer, that there was a letter that got delivered to the house, and the court's got no sympathy for that. Your mailing address is the mailing address that you tell people, and that's that. But there's other situations where investors might, from California, I'm just thinking of one in particular, might buy a property in Philly and never set foot in it and flip it. And then you've got buyers coming and saying, well, you never told us about this. You put on the disclosure, you had no idea. How did you not know that there was a flood in the basement? And they just simply say, we weren't there. And the court says, these are investors. They never lived there. You knew that their mailing address was California. There's no reason that they should be held to this. And they were honest that they had no knowledge of a flood. So that becomes sort of a tricky kind of a lawsuit, but they do exist and they are successful.
Right. And you're right. As an agent, we have to give full disclosure, especially once we've received constructive notification, that it's not a rumor or something. I have to confirm that it's true or not. But we are held to a higher standard that I can't just say I took my client at his word. Mm-hmm. I'm required to do that investigation and confirm. Mm-hmm. Did I go to the construction office and check on those permits, or did I look into this further? Because just saying, well, that's what they told me doesn't get me as a licensed agent a get out of jail free card.
Right. Correct. And lawyers are the kings and queens of that, where we say things like, according to my client, all work was done to code, where it sounds like we're saying something, but we're really not. You know what I mean? We're just saying that's what they told us, and all we're telling you is what they told us, meaning that I didn't go ahead and confirm any of what I'm about to relay to you.
So that trigger, and I've heard other agents use this claim, especially when it's a disclosure dispute, that it's consumer fraud. But is it consumer fraud if the seller does it or if the professional does it? Where does that come into play? It's
every single seller's disclosures lawsuit contains that count. I think because if successful, it allows you to triple your damages. From what I've seen, it usually gets thrown out because I don't think that the seller himself can be held to that. I'm not so hip on all the ins and outs of the consumer
fraud act, right? But I find that they usually do it because I put my signature on that too as the seller's broker. Uh-huh. So I usually think they're trying to get me for that side of it, right? When I say me, I mean a licensed agent, not me. I've never been sued in this business, so.
Right. So maybe it triggers your insurance, and then someone settles out, kind of a thing.
Yeah, all right. They know I've got $5 million in E&O insurance, so they're trying to trigger that because my signature's on the document and I attested to it. Mm-hmm. We're at the table. You review all those documents with your buyer or seller, and then it's just a handshake. You're there just to make sure that they don't go down, they don't expose themselves to anything legally, and that they fully protected themselves under the law from either side of the table, right?
Right. It's helpful in the sense that if I'm there, any questions that come up don't get swept under the rug. They get answered to a level of satisfaction. And it eliminates the possibility that people can claim that there was confusion or any kind of sneakiness at the closing table, which oftentimes can devolve, as I'm sure you're aware, into arguing and bickering, and oftentimes just extended periods of boredom where you're waiting for things to happen outside of the office that you're in. But I think having an attorney there is smart from that perspective too.
And usually it's nothing material; it's something stupid.
Yeah, sure, right. I might argue that a lot of the bickering is not material and just stupid. But
I agree.
It's how I make my money. So.
Yeah, I mean, I always look at every situation. A buyer wants to buy, a seller wants to sell, and everyone else wants to get paid. So why are we fighting, right? I mean, we can debate things and argue certain aspects of things, but once we get to a resolution, we should put that beside us and move on, right? I mean,
there's a lot of attorneys that should not be a real estate attorney dealing with closings because they are a hammer looking for a nail and want to flex their muscle at any chance they can, which turns them into obstructions to the deal and not someone who's assisting the deal. And
you're not being a trusted professional. They're just trying to justify their worth at that point.
Yep, and just show how tough they are, make everyone know who the attorney in the room is. I think my personality, which doesn't have that piece of it, I'm not a trial attorney, I think suits this particular niche well that I found myself in.
Well, I always joke, even when I'm training other agents on the team, that, I use the Patrick Swayze from, Roadhouse approach, right? Be nice till it's time not to be nice.
Mm-hmm.
But once you get past that point, go back to being nice again, right? It's over. All right, cool. I think that covered a lot. If anyone listening to the podcast is entering into a transaction in New Jersey or Pennsylvania, and they want to seek your counsel and your representation, what's the best way for them to contact you and reach out to you?
Our website is consolematison.com. My last name is Console, like a computer console, Console. My partner is Matison, Matison.com. You can email me at joe@consolelegal.com. That's my last name and the word legal, joe@consolelegal.com. Or they can call our main number, and sometimes I pick up, if you're lucky, 267-603-2493. Again, Joe Console. Yeah.
And when they retain you, they're dealing with you. You're not handing them off to an associate or a paralegal or anything like that. You're handling the transaction for them.
I'm not. We have 2 lawyers. We have 2 paralegals. I do all my work myself. It goes to a paralegal. They punch it up. We get it to the client to look at. But nothing is brought in or sent out without my eyes on it and my approval.
Awesome. So we're going to close out a little bit. I warned you before, we ask some random questions of all of our guests as we end our interviews. So I'll start you with the first one. We call it Tales from the Field. So what's the craziest or funniest thing you've ever seen or done, or you've seen someone else do during one of your real estate transactions?
And you primed me a little bit prior, but not enough time to actually come up with a great response. Although thinking through as we were talking, I've got one, and it's about underground fuel storage tanks. Have you ever dealt with underground fuel storage tanks? So a family member of mine lived in Washington Township for a while. They bought the house in the early aughts. They bought it from someone who had owned it since the 80s, and they sold it a couple of years ago. They make the sale. The time goes by, and they get a letter from an attorney saying, my client went to do some landscaping, and there's evidence that there's a fuel tank buried underneath. This was your duty to tell us about it. Here, we're going to sue you for this much plus this much. Can you send us a check for $12,000 so we can have this removed? We pull the whole record of the file. We have, from the year that my family bought it, we have a letter from an inspector who came out, inspected the property specifically for the fuel tank, and stated on the inspection that there is no fuel tank on the property. It was removed. And the reason that happened is because the seller from the 80s, they said we had a fuel tank in the 80s, but the block turned to gas, so we had that removed. And of course, at the time, it was like, well, we need some proof of that. And so the inspection was done, paid for, and the company said there's no fuel tank. It's as clear as black and white. That's what my family relied on when they went and sold it. And I said to this other attorney, look, here's a document from an inspection company that was hired to do this inspection. You're trying to tell me that my family should have known that there was a fuel tank when they bought the property. They were told by someone they hired to try to find a fuel tank that there wasn't one. And this attorney said, you're responsible. Someone's lying. And so this is actually potentially still ongoing, where this attorney is trying to sue all these past owners. Imagine owning a property 40 years ago, paying for a fuel tank removal, and then, out of the blue being told that it wasn't removed, and we don't even know if it's actually there. It wasn't removed, and any leakage that happened since 1989 or 1987, whatever it is your responsibility because you lied when you sold it. So it's just a weird situation that is accusing folks of being dishonest who don't have that bone in their body, and it just shows you how things can get ugly quick.
They do. I actually had one. Underground storage tanks are nasty, and I advise all buyers and sellers to proceed with extreme caution. The financial ramifications of one of those tanks leaking could be catastrophic for anyone. I had one in the Pinelands. Luckily, this particular seller had a tank insurance policy, which you can't even get anymore. The insurance companies figured out that this is a bad deal for us. But he was fully insured, luckily. And it had a pinhole leak in it in a sandy soil with a high water table. But what was amazing to me is when they took that tank out of the ground and sent it back for forensic study, they knew what shift it was welded on, who the welder was, how long that pinhole's been there. Mm-hmm. And then the insurance company went back through that chain of ownership and went, okay, you owned it for 10% of this time. You're on the hook for 10% of this cleanup. They went back to the chain of ownership and tried to see.
Wow.
And I guess it carried a little bit more weight because once it touched the water, the injured third party becomes the state of New Jersey.
Right. And so that's what's happening here is they're claiming, well, you know what? We could report you because we believe there's an underground water table that was affected by this. And if that's the case, here's what's triggered. And you're not allowed to waive knowledge. Just the fact that you own the property while it leaked is enough for you to be in trouble for it. Yeah. And there is some truth to that. Although there is also some exceptions for strictly residential purchasers who can prove they had no knowledge. There's been some recent case law that has allowed those folks to get out from under the New Jersey state piece of that. But you can still be civilly liable to the new buyer, which I'm not.
Yeah, so it's scary. Make sure you get a tank sweep, you get the documentation. If they said they removed it, make sure they did it with permits and got all their documentation back. And unfortunately now, though, we used to, on every clean pull 10 years ago, we'd get a no further action letter from the state. But now they only issue the no further actions if there was a cleanup triggered. There is no further action on a clean removal.
So I guess there was a time when converting to gas was just a very popular thing. So that's why this comes up so often.
Yep. And I would love to meet the person that thought it was a great idea to put steel tanks underground filled with a contaminant, because they would rust. I would think they would rust. All right. So before we close out, we'll give you some of the easy stuff. So, Joe, what is a noise that you love and a noise that you hate?
A noise that I love. How about bacon sizzling?
Ooh, good one.
That to me is a good noise. I'm getting hungry for lunch just thinking about it. And noise I hate might be my 3-year-old son's whiny voice that he's in a habit of deploying for no reason or any reason right now.
3-year-olds are persistent negotiators, aren't they? I should hire them all to be on my team because they do not take no for an answer at all.
He's so good. It's like he can repeat himself for an hour straight. I want a snack. I want a snack. I want a snack. And at some point, you're just like, well, maybe he deserves that snack. He put in a lot of time to get it.
So let's do another one. You're walking through the family room. The kids aren't controlling the TV with Paw Patrol, and there's a movie on, and no matter how many times you've seen it, you're going to sit down and watch it no matter what point in the movie it's in?
Ooh, I did that. Although I probably wouldn't have thought this, but I caught the second 2/3 of The Godfather the night before last, and I once I started, I was like, every scene's amazing. So what am I going to do? And so I ended up the original Godfather. I ended up playing through that whole thing. So that's fresh in my head. I hadn't had cable for a while, and I got YouTube TV to get back in with the sports that are coming back now. And now I'm actually back to flipping through channels. So I like catching stuff. So I'll stick with The Godfather. All-time favorite movies, probably Pulp Fiction.
They're both great, and I can sit down for either one, no matter, even if it's the last 10 minutes or the first 5 minutes. I'll sit down and just dive in. Especially, I love Godfather 1, but definitely Godfather 2. When
it's so good.
All in Italian. It's amazing. It's absolutely amazing. And as every male in America, we always quote either Godfather movie, right?
my dad uses the leave the gun, take the cannoli line. I would say every time that I see him.
Knowing your dad, that one does not surprise me at all.
He's giving me an eggplant parmesan. He substitutes cannoli with eggplant parmesan.
And you're in between appointments. You're in your car. There's that one song that comes on that you crank up and you jam to it and sing out loud, no matter what it is. It's like
I'm gonna go with a local favorite. And I'm gonna say Rosalita by the Boss, Bruce Springsteen.
Nice. Yeah.
So good.
That is a good one. So what's on the bucket list? What's that number one item on the bucket list?
My wife and I were 2 years ago was our fifth year anniversary. We were going to do 2 weeks in Portugal. It didn't happen. We rescheduled it for this April. Bought everything, had everything booked. We're so excited. And then, I'm not saying woe is me because we got all our money back, but that was the bucket list, was to just go to a country we hadn't been before, to neither one of us had been to, and spend some time together. Our lovely mother-in-law, my mother-in-law, her mother was willing to watch the kids as a sort of a anniversary present to us, and we were so excited, and that like if not a lot of people have suffered a lot worse, so I'm not complaining in that respect. But
no, I know, but it's a big hit no matter what, right? It's not a financial hardship, but it's an emotional kind of hardship, especially for an anniversary thing that gets postponed like that.
As the days ticked by, March 19th, 20th, and we're like, what's going to happen? And at some point, it was just a foregone conclusion that we were done. So I would say the bucket list would be to re-engage that when appropriate and get back on the road.
So I think I know the answer to this one. I'm pretty sure I do. So what's that one thing about Joe Console that, unless someone knew you personally, they wouldn't know is an obsession of yours?
Could it be the rock band Fish? Is that what you're going to say?
That's what I was going to say. Yeah.
That's an obsession of mine. I've clocked about 140 shows so far. A small but not insignificant with your daughter.
Yeah.
And an even slightly larger slice with her husband.
You guys are missing one in August, right? Next month you were supposed to have one in AC, right?
Three. Supposed to be three.
Oh, three. I'm sorry.
I was supposed to see 2 in Hershey and 3 in Atlantic City, and that's hopefully they're rescheduled for next year. Hopefully that's what happens.
So your final question, then we'll let you go because I know you're busy. You got to start billing people by the hour to make some money there. But
I'm not billing right now.
You're doing it right now, right? So if heaven does exist, what would you like to hear God say when you arrive at the pearly gates?
Oh, geez. All right. Well, we'll ignore how I might feel.
Said, oh, geez.
We'll ignore how I might feel about that personally. But I think something along the lines of, Joe, you were kind to everyone you met as a default. And I'm hoping that that's good enough in a world where God doesn't care what my belief system is. If I can operate from a place of kindness and gratitude, I'm hopeful that there is no benevolent God that would have a problem with me. And so
I agree with that one. I think that's right. I think if God does exist and heaven exists, I don't think he's worried about the churches and the man-made stuff, that we live our lives, that we assist those lesser among us, and we love and treat our neighbors and those around us the way we would want to be treated.
I think it's a moral imperative, and I could go down this rabbit hole for the rest of the day. But I think that there's a moral, I don't need to be told. I never needed to be told what it meant to treat someone with the golden rule. That to me just seems like a moral imperative. Like it exists just because we live in a society, and I don't know. So I let kindness guide me to the detriment of money in my practice a lot, but I'm happy with where I'm at.
Well, my business coach, Brian Buffini, says all the time, if you give it out in slices, it'll come back in loaves.
I like that.
I still believe in that, right? That sometimes you do things that either cost us money as professionals, or they definitely don't make us money, and we're not looking for the payback, but then out of nowhere, when we're least expecting it, that payback, that return comes from it, even though we weren't expecting it.
Mm-hmm. Yeah, I got a mentor that, what was his quote? I'd rather have a fourth of a watermelon than an entire grape, kind of a thing.
That's a good idea. Yeah, that's another good one. Yeah, absolutely. Well, I had a blast with you. Can't wait over the summer. I'll probably go crash in your Ocean City house next month, maybe.
Yes, bring the party. We'll be there.
Absolutely. And then anyone out there listening, you had the contact information earlier, but Joe's a great real estate attorney, all of Pennsylvania and New Jersey. We covered both states completely. Highly recommend them and entrust them with our clients. So I have no problem recommending and telling you to reach out to them if you're entering into these transactions or you have any questions.
Thank you,
a lot for your time. I know you're busy and swamped, especially at the end of the month like this, like we are, and I really, really do appreciate it.
Put my contact in the show notes. That's something they always say on podcasts, right?
It'll be in there. So everybody, keep notes. Take care, Joe. Take care and be safe. And keep me posted on the Atlantic City deal.
Will do.
All right. Thanks.
Thank you for tuning in to this week's episode. If you would like any additional information, please contact us at Teamclyderealtors on Instagram or Facebook, or you can send us an email at Steven@Teamclyde.